Thank you. First, I would like to say thank you to the members of the committee. I know you've had a lot of work to do and have a huge amount of work to do this time around. Big scorecard, I guess, to keep track of everything. And I really do appreciate the effort that you put in, because it is very important for our system of justice. So here I am again. I always like to spend some time thinking about what is it I'm supposed to say? What am I supposed to talk about? And I probably talk about the same thing most of the times. There are, I guess, a number of different things that I think are important for someone who's going to serve as a judge, and even more so for someone who is interested in being a justice on the Iowa Supreme Court. I've got a list of 4 things, I think. I'm sure you could make up longer lists or shorter lists, or do them differently, but number 1, I think, has to be a concern for justice. Number 2 has to be the intellectual ability to carry out the responsibilities of the position. My number 3 is life experience. And number 4 is a desire to do the job, to serve in that position. Regarding the first thing, justice. I have a real passion to see justice done. I think that that's demonstrated by my 25 years as a legal aid attorney. I also think that some of my service on bar and court committees to try and make the system work better also shows my interest in justice, because it's always important to improve how the system functions as society changes. Intellectual ability. It's always interesting when you're in an interview, because you have to come in here and tell people how good you are and why they should pick you, but you don't want to sound arrogant. So you always have to shoot for that reserved confidence, I guess. I hope that's what I've tried to project. I think that my abilities as a lawyer have been demonstrated by the casework I have done. I very much enjoy doing legal analysis, and in fact I do spend a lot of time doing legal analysis, working with other attorneys, working on briefs that they're working on, helping them out, things like that. So I think I have the necessary ability there. The next thing on my list was experience. As I already said, I have 25 years experience as a legal aid attorney. It's probably a little different than most of the other people who are applying, but I think it gives me some insight into how the legal system affects people who are the most disenfranchised in our society. And I think it's important that that point of view be part of the makeup of decisions that are made by the Supreme Court. I think it's important that on an appellate court you have a diverse group of people who have different life experiences, because there is that sort of practical thing that making a decision, you really need to understand what are the practical implications of this. And I think my experience in assisting single mothers in domestic violence cases, dealing with poor people with all kinds of issues that they may have, my experience in dealing with disabled people and how the system is difficult for people in those situations is a plus. I also have some experience with a couple of things that I think are important for the wave of the future as the trends in the judicial system. And that would be dealing with pro se issues. As I'm sure you know, I was on the committee that drafted the pro se family law forms. And I also have experienced our transition at Legal Aid from paper files to electronic case management. We have a statewide database, and I was a manager during that time, so I'm used to that. I know how to, I don't consider myself a technology whiz, but I know how to make practical use of it and think through what are the ways that we can make this work. I think I'm up to number 4. A desire to do the job, a desire to be in the position. If nothing else, I guess the number of times I've applied indicates that. It's not that I like rejection, but I do feel that I guess I have a real desire to do the position, and if there's an opening, I should maybe put myself in a position where the committee can decide, is this the person that would be a good fit for this. And I guess finally in connection with that, I would just like to say that service is important. It sort of hit me yesterday. I was in church and the pastor's sermon, he mentioned something about leaders and how important it is to have a servant attitude. And when you are in a position of leadership, it's important to remember that you're there for a purpose, and that's to serve whatever group you're in that position in. And so I think as a person it's important that a person on the court have that, recognize that servant role of a leader. I think that's all I have for my remarks.
Thank you. Do we have any questions on the right side here? Mr. Pace?
Mr. Tenuta, hi. Nice to see you again. Thank you for putting your name in. I just want to thank you for your 25 years of work on legal aid. I do a little bit of volunteering over there and see the kind of people and the needs they have when they come in, and it's just incredible the amount of folks that really need assistance. So thank you very much for everything you've done on that. One of the things I know you
And the first thing you always have to say in that situation is there are no easy answers for things like that. In my experience, I've gone through the ups and downs. I've been at times where I had myself and one other attorney in my office in Sioux City. I spent 2 years managing our Council Bluffs office because we've been in situations where you have hiring freezes and you have to make do. I think as we go forward, I think one of the obvious things is using technology. And I know we're going down that road, and I think we need to keep going down it. That has been a huge help to us, in my experience, and it's tough because people don't like change. And there's always going to be people who say, yeah, but we don't have this level of personal service, or whatever it may be. And I think there is some truth in that. On the other hand, if you can step back and look at it objectively, you sort of have to quantify this. Are you making yourself more available? How are you doing that? And this doesn't translate directly, but just to give you an example, we have a statewide application system now. And that means that we use people all over the state and a phone system that's connected via the internet and a chat room and a secure website database and all these kind of things. And what it's done is made us more available for people to do applications. When most of my career at Legal Aid, we took applications 3 times a week for, a few hours. Now we're doing them in all of our offices every day, morning and afternoon. It's a different way of doing things, and you maybe don't always get quite as much personal services as you would like. But when you have scarce resources, you have to make things work.
Any other questions on the right side? Mr. Fitzgibbons?
Good morning.
Good morning.
Thank you again for being here with us. I think one thing that perhaps those who do not pay a great deal of attention to this process don't know the individual characteristics of the individuals that come here seeking a position on a higher court. And I think anyone looking at your body of work over the many years that you've practiced has to come away impressed. Honors graduate, University of Minnesota, honors graduate, University of Wisconsin. And you've put aside perhaps the pursuit of making a lot of money in the practice of law, if you can do that. I don't know if you can. But it's incredible that you have given the service you have to the less privileged in our society. And I hope anybody that looks at this process will see your body of work and the body of work of many others who come here as truly outstanding individuals. Having said that, tell me a little bit why you think in the area of doing the type of work you have, and knowing that's a bit different than the vast majority of lawyers and or judges that come before us, why that uniquely qualifies you, what perspectives it's given you, and what you think you can bring to this job.
Okay. I think the answer to that is my whole speech.
You said it much better than me.
Well, you know, we all know, in anything, lawyers know that there are very practical implications for decisions that get made. And everybody in life has different things that they're experts in, and they have experiences, and they know that practical decisions that get made have practical effects. And you know, I think about that. When the court decides something about the amount of evidence that gets, or how evidence is put into in a small claims court, for example, how does that affect people? It's maybe easy to think, well, small claims court, we're only talking about $5,000. That's not very much. Well, it's a lot, but you know, to most of us in the system, that's not a huge case. Okay, but to some of my clients, that's more than they could ever even think about saving up in their lives. When they're getting evicted from their home, we hear a lot about, you know, the mortgage crisis, and I think most of us probably who have mortgages relate more to people who can't make their house payment than we do to the tenant who is basically living check to check and is about to lose things. How important are the procedures for that person? I've always been a big believer that procedures are very important because people deserve an opportunity to get heard. And even in cases that we might think of as being, well, that's not quite as important as that, those procedures still need to be fair. And I'm not suggesting that we need to have as elaborate of procedures for a small claims case as we do for, you know, a $1 million tort case or something. But the procedures do need to be fair, and they do need to give people an opportunity to be heard. And I think that's something I understand on a very practical level of what it's like to go in to some of these situations where you already know that the cards are stacked against you, so to speak, because the system is not recognizing the plight of your client. And I would also add to the people who are disabled, because we still have a sort of attitude that this person's disabled, we're going to figure out what's best for them, as opposed to letting them have the maximum amount of input. And I think a lot of my experience has been trying to relate to people and understand how they deal with the system and trying to make sure that system is as fair as possible to them.
Thank you.
Do we have any questions on this side? Yes, Ms. Skogers.
I will try not to have a coughing fit this time. Mr. Tenuta, I understand that you have a pretty enormous caseload over there at Iowa Legal Aid, and that you're both a managing attorney and that you also handle your own caseload. Is that correct?
Yes, that's right.
Could you maybe talk a little bit about how that experience might lend itself to service on the Supreme Court?
Okay. One of the things, and believe me, I spend a good amount of time wishing I was just a, I hate to say just a, because staff attorneys are what make our program go back to being a staff attorney where I didn't have to worry about some of this other stuff. But the other stuff is important because it's the other stuff that allows the staff attorneys to do their work, or me as representing someone. So you do have to have that balance between administration and being able to see how the system works. And you know, I interact, of course, with a lot of attorneys who they want to deal with their cases, and they're not always happy with systems decisions because they're focused on what they want to do, and they see those as kind of getting in the way. And part of my job as a manager is to try and get them to understand, okay, this may seem like it's a hindrance, but in reality, it's making the whole system function, which is what enables you to do what you're doing. And so you have to have that balance. And so, you know, part of I have responsibility for just managing people. Can I take some sick time? Can I take vacation? Making sure that the schedules, there's someone filled in all of these slots. And, you know, of course, you got people working on those things too, but when you're the manager, it's your responsibility to make sure that everybody's taking care of those things. And then a lot of what I do is case triage. So I have cases that are taken in through our intake system, and I have to decide, does this go to representation? Does this go to a staff discussion where we decide, are we going to get further help? Is this something that we just need to, you know, I hate to say push out the door, but give them some advice because that's the best we can do given their situation and our situation. So you really do have to balance. How does that apply to a court system? You know, I think that applies to almost anything you do. And of course, in the court system, if there's any place where you have less control over the number of people coming in than you do at legal aid, it's the court system. Because we at least say, well, you still have to meet this income qualification. When you're in the court system, you have everybody coming in, and you can't just say, well, you know, sorry, we don't have enough people to help you today. And so you have to be able to figure out ways to balance all of those things and get people into the system and come up with, you know, different ways within the system to take people who have different kinds of cases. And I think, you know, small claims is a good example because in a small claims case, you have simplified procedures, and that's perfect. That's what you need there. And there are other kinds of cases, you know, that really the procedure should be different. Family law cases are probably not going to have the same kind of procedures as a consumer law case, et cetera, et cetera.
Mr. Brody.
Working collegially seems to be very important in this room. Can you give me some examples on your work ethic around working collegially, and what would your colleagues say about you working with you?
I hope they would say nice things. You know, at Legal Aid, that is one of the primary things that we do. We work together as a team. In fact, the person that I've probably worked the closest with over the years is Chris Luzzy, one of our litigation directors in Iowa City, and that's become even easier with the increased use of technology. And so we spend a lot of time on the phone if we're working on a legal argument, going back and forth, and you have to be able to be frank with people. Oops, sorry, no pun intended. And, you know, in other words, you have to say what you're thinking, but you have to be able to do it in a way that is not overly arrogant or critical. And you also have to be willing to cut some people some slack. If somebody says something to you and, you know, you think, oh boy, the tone of their voice, you know, you got to be able to let that go. Everything we do, I work closely with our staff attorneys. When you have someone who has a brief, for example, from our office, that means, and we've been working on one over the weekend, had to take time out for the Packer game, of course, but it's me, the staff attorney, and our litigation director for the most part. And we're taking turns going at it, discussing it, figuring out how we can make it better. So that's something I have a lot of experience with. And I think that the people who've worked with me would appreciate the input I have given. And of course, that's just one example. All of our management determinations, we have to work together. I've got a team of people I work with on managing the intake system, and we try to come to decisions together.
Mr. Holm?
Good morning, Mr. Tenuta, and I wanted to start by echoing some of the other comments. I think that your record in representing disadvantaged Iowans is truly extraordinary. One of the points that you made earlier in your comments was the idea of access to the courts, and I noticed in your application that you're serving on the Pretrial Procedures Subcommittee of the Civil Justice Task Force that the Supreme Court has. I realize that that's sort of a project that's in process right now, but have ideas been generated through that subcommittee about how to ensure that Iowans of modest economic means have access to the court system?
That's a tough question because we came down to Des Moines for a big meeting, and there have been a lot of ideas thrown around, and then we had some telephone conference things, to be honest, that has sort of gotten on the back burner for me lately because of some things in my personal life. But I know that some of the things that group is looking at is having different levels of procedures or different kinds of procedures for different kinds of cases. And I think that is a very good idea. I mean, it's almost like I mentioned the small claims thing, expanding that so that you have different levels of procedures that are allowed so that you discourage people from overkill, so that the amount of economic output that someone has to have in their case to get representation is more proportional to the amount of money that's involved, so to speak. And I think that's a really important thing. I mean, we see that all the time. There are a lot of people that I see that I think have cases that could really use some help, but I don't have the resources to do it, and I know that the private bar isn't going to because the cost is going to be more than that person can afford.
We have time for one quick question. Anybody? Mr. I'm sorry, Mrs. Redenbach.
Thank you. Thanks for being here, Mr. Tenuta, today. In looking at your packet and your materials here, I'm too very impressed with the skills that you could bring, and the administrative skills, and your passion for justice and for helping people. But I'm wondering if you could help me with the breadth and depth of your experience for the Supreme Court. Are there areas that you're going to feel like you really need to study to get up to speed on those areas for writing opinions and
Okay,
the
yeah, I'm going to
academic
try to
side?
make this quick. Because of my practice, I don't do and have never done criminal cases. But I think, I do have a pretty broad experience, everything from small claims to administrative law to federal lawsuits, everything from a case that's about, a $2,000 debt collection to a $500,000 case about who's going to pay for someone's services in an institution. So I think I have that. Everybody's going to come in with some areas that they're not familiar with. I do like the law and actually do try to review most of the Supreme Court decisions when they come out. Now, I don't read them word for word, but go through them and try to get the main ideas about what's going on, and the same thing with some of the Court of Appeals decisions. So I think I have a pretty good perspective on that.
Well, we thank you very much, Mr. Tenuta, and wish you the best of luck. And thanks for applying.
Thank you.
Thank you.